Christian attorney R.L. Johnson, lawforlife.us. So you've been sued. What do you do next? Well, the first thing you have to do is you have to answer the complaint. In this short video, I will show you exactly how to do that. But before getting into that, I wanted to backtrack and talk a little bit about what it means to be a Christian lawyer and the purpose of this channel. I formed this channel because of my enduring belief that lawyers should first and foremost strive to be peacemakers. One of our greatest presidents, Abraham Lincoln, instructed us to discourage litigation, to persuade our neighbors to compromise whenever we can. And as peacemakers, we as lawyers have a superior opportunity of being good men. Abraham Lincoln wanted us to know that in doing this, there will still be business enough. Now, while I can't speak for Abraham Lincoln, I believe that he was informed in large part by the Prince of Peace's instruction that we should comport ourselves in such a way that all men will know by our actions that we love one another. So in my practice, what I strive to do is to first vigorously advocate for the client, but at the same time recognize that at the end of the long road of litigation, the client needs to find peace. And I go as far as to say that lawyers are uniquely situated to do just that. People come to you sometimes with their lives in disarray, often on the brink of losing everything. Standing side by side with the person, or sometimes standing in front of them as they face challenges and sometimes almost certain disaster, while at the same time recognizing the fact that the last thing they need is someone to spray gasoline on smoldering embers. This to me essential to what it means to be a Christian lawyer. Consequently, one of the purposes of this channel is to make the law accessible to real people and not just the exclusive province of attorneys. With that being said, I want to turn to the purpose of this video, which is to help people realize, understand, and be better equipped to take action in the event that you're sued. The first thing you have to realize is that every state has its own rules governing civil procedure. Now, the statutes, laws, or rules under which you may be sued are governed by substantive law. And that is to say, the laws enacted by Congress, a state legislature, city government, or a township. But the rules of civil procedure govern and determine the interworkings of a courthouse and individual proceedings. So, for example, what constitutes a proper document filed with the court will in large part be governed by the rules of civil procedure, and let's just say in the courthouse where the document was filed. Now, recognizing that there are hundreds, if not thousands, of different rules in play at any given time, in particular the venue in which you are sued, I'm going to confine this presentation to the rules governing federal civil proceedings. And those rules are known as the Federal Rules of Civil Procedure, sometimes FRCP. Now, the Federal Rules of Civil Procedure have been adopted in almost 35 states in our republic. And even those states that have not adopted the Federal Rules of Civil Procedure in their local courts have rules that very much mirror the federal rules. So a good starting point for talking about how to respond to a lawsuit is to look at the Federal Rules of Civil Procedure, because they are and have been the lodestar of civil practice. But again, if you want to find out the particular rules in your state, or more precisely governing the court in which you are sued, you'd have to turn to those precise rules, most of which are available online. Now, I will be putting together another video that illustrates exactly how to go online and find the laws affecting your particular jurisdiction, and I will place that link in the description box. But again, for the purposes of this video, I'm going to confine my analysis to the rules governing federal civil procedure. One additional caveat: I trust that everyone understands that the information I'm providing is for educational purposes only and cannot be applied to any specific set of facts. And to the extent that individuals have questions and are in need of legal help, I would strongly urge you to seek the advice and counsel of a qualified attorney licensed to practice in your jurisdiction. With that being said, a lawsuit is commenced when someone files a pleading, and usually that pleading is referred to as a complaint. The term pleading itself needs to be defined. So what is a pleading? A pleading is a complaint, an answer, a counterclaim, or a cross-claim. And I'll circle back and define each of those terms. What is a complaint? Essentially, a complaint has three parts. The first is a plain and short statement of the grounds of the court's jurisdiction. And jurisdiction is a court's power to hear a complaint. Now, in order to have jurisdiction, the court has to both have power over the individual and power over the subject matter. For example, there are courts that hear nothing but criminal cases. And as a matter of fact, they're the only courts in that particular jurisdiction that can hear certain criminal cases. There are courts that only can hear landlord-tenant cases, for example. And who determines which court can hear what cases? The state legislature usually, or Congress. The second thing a complaint is a plain statement of the claim. In other words, what is the person complaining about? What wrong does a person believe was done to them? And thirdly, it is a demand for relief. What do you want the court to do about your grievance or your complaint? Having received a complaint, the defendant, or often oftentimes in civil proceedings, the respondent has to now answer. So what is an answer? An answer has three parts, essentially. It contains admissions, denials, and defenses, which are stated in short and plain terms, which either admit or deny the opposing party's allegation. Now, oftentimes when someone's been sued, they're very familiar with the plaintiff, and they may have even anticipated that they may be sued. But having interacted with the plaintiff, they may have their own complaints or grievances against the plaintiff. And this is where the counterclaim comes in. And a counterclaim is brought by a defendant against the plaintiff. Many lawsuits don't just have two people or two entities. Many lawsuits involve multiple plaintiffs and multiple defendants. And sometimes those defendants and plaintiffs have grievances against one another. This is what's known as a cross-claim. And a cross-claim is a grievance against a party on the same side as you. So you may have a complaint against a co-plaintiff, or you may have a complaint against a co-defendant. Now, the other thing that typically happens in a party's response to a complaint or counterclaim or even a cross-claim is an affirmative defense. So what's an affirmative defense? An affirmative defense is a defense that has a good faith basis that negates liability. So for example, if it was a breach of contract case and the plaintiff alleges that you failed to comply with or discharge a duty under the contract, and you had a good faith belief that the contract was rooted in fraud, then an affirmative defense would be that the contract was procured by means of fraud. In addition to having a good faith basis for asserting an affirmative defense, you also need to assert it, or it may be waived. So at the time that you answer your complaint, or at the time that you enter your cross-claim or counterclaim, if you have an affirmative defense, the rules of civil procedure require that you assert it then, or your defense may be deemed waived. Also crucial to answering a complaint or participating in a lawsuit is to ensure that you meet all of the time frames that the rules provide. Many lawsuits are lost by default because the defendant failed to respond in a timely fashion. Sometimes people get sued and they, possibly because of the initial shock of being sued, spend a lot of time in analysis paralysis trying to figure out what to do. Sometimes they're reaching out to the plaintiff to try to resolve the matter informally. Sometimes they're talking to friends and family, or maybe even consulting with attorneys, but they don't actually answer the complaint or hire anybody to answer the complaint for them. Days go by, weeks go by, and the next thing you know, you're being served with a notice of default, which is another way of saying you essentially forfeited your right to participate in the lawsuit. This is the easiest way and the worst way to lose a lawsuit, because once that default's entered, the only way you can file documents or participate in the lawsuit is to have the judge or magistrate set that default aside, which is a very difficult process. It usually requires you to show a good faith reason for not responding in the first place after having been served, and also that had you been allowed to participate in the lawsuit, you would have had a meritorious defense to the claims against you. Most people can't overcome the first prong, which is a good faith basis for not answering the complaint in the first place. And as many people know, when a lawsuit is filed in a court and served upon a respondent or a defendant, is either done so by the U.S. postal carrier, who will usually have someone sign something indicating they received a document, or served upon you by an officer of the court, sometimes referred to as a process server. Once proof of that service is provided to the court, it's very difficult after enough time has elapsed to say, I wasn't aware of this lawsuit. So the worst thing that can happen, and the easiest way to lose a lawsuit, is to do nothing, or to wait too long to do something about it. So here's an abridged table of the time frames associated with receiving your complaint and responding. So once you are served with the complaint, and again, that's usually either by the postal carrier, who will have you sign for the document, or it's by a process server, who doesn't necessarily have to have you sign for the document, but only needs to identify that you are the person named in the complaint and affirm to the court under oath that they served that document upon you. Sometimes they'll drop that at your feet. Sometimes if people refuse to get out of the vehicle and a process server approaches you in your vehicle, they'll, having identified who you are, slide it under the windshield wipers. Having done that, the court officer then swears out a document that he or she files with court, indicating that they identified you and gave you the document. But however you're served, you have 21 days after being served to file an answer with the court. Now, in some cases, you have 28 days. In some jurisdictions, they may not count as Saturday. And in almost all cases, there are rules governing how people can be served. For example, people typically cannot be served inside a sanctuary of a church. But again, those are rules sensitive to the jurisdiction where the proceeding is occurring. But under the federal rules, you have 21 days after being served to answer. Now, many times people will ask the court for more time because they need to investigate the matters being alleged in the complaint. And oftentimes, either the other side will agree to give you more time, in which case there needs to be an order filed with the court extending the time, or the court itself, having been presented with the proper motion, may grant you more time to answer. But if you receive notice from the court after you file a motion requesting more or time that your motion is denied, then you have 14 days after that denial to file your answer. Sometimes people file a motion asking for a more definite statement, meaning the allegations in a complaint are ambiguous, vague, or unclear. If you ask the judge to direct the plaintiff to clarify what they're talking about, that's often referred to as a motion for a more definite statement. If the judge does grant such a motion, then the plaintiff has 14 days to correct or cure whatever faults were found with their complaint and serve those upon you. Having received that clarified statement or set of allegations from the plaintiff, you then have 14 days to answer the complaint. And also included in that category of rules are motions to strike a defense. You'll recall earlier I talked about a good faith basis for having a defense. If you assert an affirmative defense and the plaintiff says, well, there's no good faith basis for the person saying that there was no fraud or anything of the sort involved in our transaction, therefore there's no good faith basis for such a defense, and they file a motion with the court asking the court to strike that defense, then the plaintiff has 21 days to file that motion with the court. And that 21 days will begin to run on the day they receive your defense. Now, with that overview in hand, I want to provide you a practical example of what this whole thing might look like. And again, I'm going to use the Federal Rules of Civil Procedure and two of the federal documents that are provided for pro se litigants. Pro se litigants are people who are representing themselves and have chose to not engage attorneys in either their complaint and request for relief or in their defense. So the place to start is uscourts.gov. I provided a link in the description box to the U.S. Courts website and the Pro Se Forms link where you can find a sample complaint created by the federal court, which contains all of the elements of a complaint that are required in order for your complaint to be considered legally appropriate. So if you cut and paste that link and you put it in the address bar, you're going to receive a result similar to this, which will take you to the Civil Pro Se Forms page on the U.S. Courts website. And we're going to do a quick search and we arrive at the Google page where that is found. And we're going to go to Pro Se Forms and we're going to click, and you'll see 15 different forms that the court created for pro se litigants. And the first form on the list is the civil complaint. Notice that the third form on the list is defendant's answer to the complaint. Now, again, these forms are specifically designed to address and comply with the Federal Rules of Civil Procedure. However, the process is essentially the same in any court in which you may be sued. When you look at the form, you'll see the crucial elements that every court would require in some form or another in order to file or respond to a complaint. But here we're going to click on the complaint for civil case, and it's going to take us to another page where you have an option of downloading either a Word version of the form or a PDF version of the form. I would recommend the PDF version because it's less sensitive and much more stable than the Word version. Also, we're going to download a version of defendant's answer to complaint, and notice that's Pro Se Form number 3. So let's start with Pro Se Form number 1, which is the civil complaint. In the interest of time, I have already populated all of the fields, but let's quickly go over this form. Now, in our lawsuit, the plaintiff's name is John Q. Public and the defendant's name is Sally H. Cope. Notice how the form all provides instructions at each stage. This is the court's effort to make the form and the process as user-friendly as possible. Many jurisdictions have pro se forms, many do not, but the elements that are provided here on this federal form will, in at least 35 states and republics, be sufficient to meet the rules. At the top of the form, you see the jurisdiction of the court. In this case, it is the United States District Court. If it was a state court, it might say State of Alabama, and then beneath it, it would list the venue of the particular court. But in this case, it's the Middle District of Alabama, and it is a civil division as opposed to, say, the criminal division. Notice off to the right, you have a case number, and this case number is assigned by the court clerk's office. So it's not something you would ordinarily fill in, but I just filled it in just so that folks would see what a number might look like. And the plaintiff has the first opportunity to determine whether or not he or she wants a jury trial or a non-jury trial. Now, if the plaintiff was to indicate they did not want a jury trial, the defendant could demand a jury trial because a jury trial is a right afforded to litigants, but you have to request it early on or the right is waived. In this situation, John is making a jury demand. The other thing about jury demands is that it typically will enhance the fee you have to pay when you file your case. Now, typically, the first thing that you have to indicate on your complaint are the parties, their names, their capacity, whether they're individuals or they're businesses, where they're located, where they do business, or where most of the, in the case of a business, assets are located. And in so doing, you're helping the court understand whether or not it has jurisdiction over the persons or the property connected with with your case. As you can see, John provides his own information, and below that he provides Sally's information. Notice that John lives in Florida and Sally in this hypothetical lives in Alabama. Next, you have to tell the court what is the basis for jurisdiction. Now, in many state court cases, you may be required to provide the court with the state statute that governs the proceeding that you're commencing. And again, many courts have forms for this, and the forms, for example, in a landlord-tenant proceeding, may already posit that information on the form, but just in case it does not, you are required to research and find out the legal authority for bringing a claim that you're bringing. But in the federal context, there are only two ways you can enter a federal court. One is if your case in controversy involves a federal question, and that's usually something having to do with the United States Constitution or federal laws or a treaty or some other issue that the courts have traditionally treated as being a federal matter. For example, employment discrimination cases are generally considered federal question cases, as are civil rights cases. That's federal question jurisdiction. The other basis for jurisdiction is diversity of citizenship, and that is the basis upon which John is relying in this hypothetical complaint, namely that he is from Florida and Sally is from Alabama. If this is in fact true, then there would at least be a basis for the court to review this as a result of the diverse citizenship of the parties. Notice that even though it's already alleged in the complaint above that John is from Florida and Sally is from Alabama, at paragraph B, John has to explicitly state that fact. Notice also that if John was actually a corporation, say John had his own dog grooming business in Florida, and it was the dog grooming business, not John, who was bringing the lawsuit, then John would have to state not only the name of the corporation or business, he would have to put the state as well as where the business is principally located or principally does its business. But in this case, both John and Sally are individuals, so it's sufficient to simply indicate that he's from Florida and she's from Alabama. Had Sally been a corporation or had John been suing Sally's business, not her individually, he would have to indicate not only the name of the business and the state where it's located, but also where it principally does business or is incorporated and where it has a principal place of business. You have to indicate the amount in controversy. Now down below that, you'll see a paragraph that's asking if the amount in controversy is over $75,000. The reason why that number is there is because another basis for seeking the federal court's attention to a matter is an allegation that the amount of your claim is more than $75,000, not counting interest and cost of the court. And here at this line, you also have to explain to the court why your damages or your claim damages exceed $75,000. Now down at paragraph 3, John is required to provide the court with a plain statement of his claim. A plain statement of the claim does not include a legal argument. A legal argument will be something like Sally committed fraud. That's actually a conclusion that the court would make after a trial during which all of these issues, on both sides of the case, will be subjected to the rules of evidence and the rules of procedure. As a result, all the court is really wanting you to do here is tell your story based on your knowledge, information, and belief, and not to jump to conclusions that only the court can make. So in this example, I've made the case very simple in that John only has 4 allegations. The first allegation is that Sally is an individual. The second is that Sally is a resident of Anywhere, Alabama, and that she operates an unregistered and unlicensed dog grooming service. And the third allegation is that on May 1st, 2020, John entrusted his German Shepherd Rex to Sally. And finally, that on May 2nd, John's German Shepherd Rex was diagnosed with a rare skin condition. If you drop down to paragraph 4, this is where John tells the court what he wants done to remedy the harm that he is alleging was done by Sally to his dog. And again, the instruction admonishes against making legal arguments, but you are asked to provide the amounts of any actual damages claimed for the alleged acts and the basis for these amounts. You're also to include any punitive or exemplary damages claimed. Punitive damages are basically when someone is alleging that some gross misconduct took place or some intentional conduct causing injury persisted over a period of time without regard to the consequences. Exemplary damages are essentially where you're asking the court to assess the defendant's conduct and determine that an example needs to be made and reflected in a large monetary damage award. So in response to that instruction, what John indicates is that he is seeking $75,000 for medical expenses, negligence, and pain and suffering. Well, I think it's pretty clear that John didn't follow the instruction provided in the form and that he's jumped to conclusions as to the nature of Sally's alleged conduct. What the court would be looking for would be more specifics as to exactly what happened to the dog, what the veterinarian had to say about the dog, and possibly raised some allegation as to the causal connection between the dog's alleged stay in Sally's grooming facility and the dog's alleged conditions. Minimally, John would need to attach medical bills to his complaint to substantiate this claim that he suffered $75,000 in medical expenses. But it's not uncommon to see complaints drafted like this, where people make outrageous claims for enormous sums of money with little basis or supporting evidence attached to their complaint. Finally, we're down to part 5 of the form, certification and closing. You always have to sign and date your complaint. When you sign and date your complaint, even though it may not be specifically stated on any form the court might provide you, you are submitting that document under oath. And by that, you're certifying to the court that to the best of your knowledge, information, and belief, everything in the complaint is not presented for an improper purpose or to harass or cause unnecessary delay, and is supported by existing law or by a non-frivolous argument. You're also communicating to the court that if this matter was tried to a jury, you honestly believe that you could provide the court, or in that case, the jury, with sufficient information from which it could grant the relief you're seeking. Now, let's say that Sally receives this complaint, it's delivered to her by a process server, she signs for it. She now has 21 days to draft and file her answer with the court. Now, file doesn't mean put in the mail. File means the court clerk has received your document, usually stamped it received, and provided you with a copy of the stamped document that's been filed with the court. So we've already downloaded the pro se number 3, which is the answer for the complaint, and you notice it's almost identical at the top to the complaint, and this top part is known as the caption, and it will almost never change throughout your entire lawsuit. Every document you file will be required to have a caption, and the caption will always be the same. It'll have the court's name, the venue of the court, the parties' names, and the court file number. Below the caption is usually the title of the document. In this case, this is defendant's answer to the complaint. Now, of course, the first thing that the form requires is that Sally identify herself on the form as the person answering the complaint. And when we drop down to paragraph 2 of the form, Sally is instructed to write a short and plain statement of her answer to the allegations in John's complaint, number the paragraphs, and ensure that each of her answers corresponds to each paragraph in John's complaint. Sally has to either admit the allegations in the paragraphs in John's complaint, deny the allegations in the paragraphs in John's complaint, or indicate that she lacks sufficient knowledge to admit or deny the allegations. Finally, almost every jurisdiction in the Republic will allow a respondent to admit certain allegations, deny others, and indicate they lack sufficient knowledge to admit or deny the rest. So what you see now is an excerpt from my book, to which I will return at the end of this video, that illustrates what Sally needs to do to answer the complaint. In the far left-hand column, I list the federal rules that govern what John is doing in his complaint. And on the far right column of the table, I list federal rules that govern what Sally is doing in response to the allegation in John's complaint. So first, under the second column, allegations in the complaint, you can see John's 4 allegations. Sally Coate is an individual. And in the next column, you'll see Sally answers by admitting that paragraph 1 is true. She is, in fact, an individual. Paragraph 2, John alleges that Sally is a resident of Anywhere, Alabama, and that she operates an unregistered and unlicensed dog grooming service, to which Sally answers that, yes, she is a resident of Alabama, but she denies the remaining allegations in the preceding paragraph because they are false. And a specific rule that gives her license to respond in that way is Rule 8B4 of the Federal Rules of Civil Procedure, which allows you to admit part of an answer to an allegation while denying the balance. Third, John alleges that on or about May 1st, 2020, he entrusted his German Shepherd Rex to Sally, to which Sally responds by denying each and every allegation in that paragraph. Fourth, John alleges that on May 2nd, 2020, his German Shepherd Rex was diagnosed with a rare skin condition, to which Sally, under the authority of paragraph 8B5 of the Federal Rules of Civil Procedure, responds that she lacks knowledge or information sufficient to form a belief about the truth of this allegation, and therefore denies every allegation in the preceding paragraph. This is a table illustration of how Sally would respond, how a response is organized. Now, the way that Sally would actually draft and provide this information to the court, really as page 2 of her response, would look more like this. Sally would take a plain sheet of paper, and at the top, she would identify the court, which in this case is the Middle District of Alabama Civil Division. She would list the parties, John and herself, and she'd list a case number. It's a good idea to do this on every page of any document you attach to a response or a pleading filed with the court. That way, way, the clerk in the clerk's office can easily identify and ensure those documents don't become separated from your case file. But you can see that Sally indicates that this is her answer and her defenses to the complaint. Per the rule, you're required to repeat John's allegation. So she restates his allegation exactly as it is in his complaint, and below it, she answers it. And she does the same for each of John's allegations. That is, she simply retypes the allegation on the separate page, and beneath each allegation, she answers it according to the rules and her information, knowledge, and belief. So as you can see, Sally admits paragraph 1. She admits only that she is a resident of Alabama for paragraph 2 and denies everything else. For paragraph 3, she denies each and every allegation in paragraph 3. And for paragraph 4, she indicates she lacks knowledge or information sufficient to form a belief and therefore denies the entirety of paragraph 4. Now, having responded to each allegation in John's complaint, now, we'll note that failure to respond to an allegation is treated as an admission. So if John has 4 paragraphs in his complaint in which he makes allegations and you only respond to the first 3, the 4th allegation is deemed to be admitted by you. So it's important that you either admit, deny, or otherwise respond to each allegation in the complaint. And by repeating the exact wording of each paragraph of the complaint, there can be no ambiguity as to what you're denying or what you're admitting. But not to respond to an allegation is deemed by almost all of the court rules in every jurisdiction in the Republic as an admission. So you have to answer everything. But having done that, we go down to paragraph B and we find an opportunity to assert defenses. You are required to make that assertion now in your answer, or you may not be able to later come back and claim one of these defenses. This form provides 7 defenses to which a respondent could avail herself. But the important thing to know at this juncture is that if you don't claim a defense at this stage, the court may deem that you waived your right to make one of these defenses, and you may not be able to avail yourself of it later. If you skim down the page, you can see that there are a number of ways in which a respondent may be able to completely avoid liability or trigger the dismissal of plaintiff's case altogether. In this particular case, Sally is going to avail herself of defense number 6, namely that the complaint fails to state a claim upon which relief can be granted. And here, Sally is asserting that she never met plaintiff or cared for his dog. This, if true, would completely undermine John's case, and his case would be summarily dismissed. In paragraph C, Sally is given the opportunity to assert any affirmative defenses that she might have. Well, what are affirmative defenses? Well, notice below, the court lists 19 separate affirmative defenses recognized by the Federal Rules of Civil Procedure. Again, each of these affirmative defenses could warrant its own separate video, and as such, they're beyond the scope of what I want to cover here today. But the thing to remember is that if you have a good faith basis for asserting one or more of these defenses, you must assert them at this time, or you may not be able to raise them later because the court may deem that you waived your opportunity when you had it. And again, the other caution about affirmative defenses is that if it's determined that you don't have a good faith basis for raising an affirmative defense, and this is usually determined after the other side files a motion complaining about what they believe to be the absence of a good faith basis for making your affirmative defense, and the court, after hearing, agrees with the other side, then you could be assessed fees or costs associated with that, in addition to having those affirmative defenses stricken from your pleading. Now, the next thing that Sally's given the opportunity to do is to assert any claim she might have against John. And if she had such a claim, it would be a counterclaim. The obvious problem with Sally asserting a claim against John is that above, she's already said she's never met the man. But just in case she had met John, or she had some other reason for wanting to sue John, this would be her opportunity to do so. Additionally, if there were other defendants in the case against whom Sally had a complaint or grievance, she would be required and would now have the opportunity to assert those claims against those other defendants. Now, other defendants could have been persons that John had named. For example, John could have sued both Sally and Sally's business. That would be 2 separate defendants. Or John could have sued Sally, Sally's business, and perhaps someone who worked in the business with Sally, or perhaps someone altogether different who was associated with the same injury to his dog. And the thing to know about lawsuits is that if there are persons who were involved in the same transaction or occurrence about which the plaintiff is complaining, those persons need to be brought into the lawsuit so that there can be a full and final determination of all of the claims arising out of the lawsuit. This is really important because if someone was involved and they may have some liability and they are not brought into the lawsuit by anyone, the plaintiff doesn't bring them in, you don't bring them in, and then the lawsuit is decided and settled, you may find it impossible to later go back and sue that person because now is the opportunity to bring them in, and courts aren't going to engage in endless litigation involving numerous persons who should have been brought into the lawsuit in the first place. So that's the reason reason why cross-claims and counterclaims have to be asserted at the response stage, which is the very beginning of every lawsuit. So of course, Sally is given the opportunity on the form to assert precisely what her claims are against John, if any, and precisely what her claims are against any other individual that may have had some involvement in this matter. In addition to that, Sally is given the opportunity to state precisely what damages she might have suffered at the hands of John or any other third parties that were involved in this matter. And like John, she needs to state with specificity how she was injured, how she derived her numbers, and what, if anything, she expects the court to do about it. And typically, this is where you would attach affidavits from persons who did repairs or estimates on items that were damaged. If there were doctor's costs or medical costs associated with the injury you believe the other party caused, you would attach those documents. Affidavits from professionals, either doctors or contractors or mechanics, are crucial at this stage, and often it's good to, if you're going to have estimates attached, to have more than one estimate so that the court can see that you're not just shopping for the highest numbers or numbers which more fully support your position, but hopefully opinions of unbiased professionals who have no stake in the matter. Finally, again, in part 3, Sally is to certify her answer, and in her certification, she's affirming that everything in her answer is provided to the best of her knowledge, information, and belief, that it is not being provided for an improper purpose, such as to harass or cause unnecessary delay or increase litigation costs, and is supported by existing law by a non-frivolous argument or an attempt to reverse existing law. She's also indicating that in this case, should this matter reach the stage of jury trial, there's evidentiary support for everything that she states in her document. Sally then signs the document, dates it, and as I indicated, ensures that the clerk has it, and if she physically is in the courthouse, she would take 2 copies of her answer, ask the court clerk to timestamp and date one, and file the original. Now, a note about e-filing. For over a decade, all of the federal courts have been e-filing courts, which means that all documents filed with the court, especially by attorneys, have to be done electronically to a server maintained by the court. And if this was the case, the e-filing clerk, having reviewed Sally's documents or any documents submitted by a party, would notify you that the document has been received. Usually you're notified by email that the document's been received. That email contains a link. You click on the link, it takes you to the filed version of the document, and usually along the spine of the document, it'll have the court's stamp with the date and time the document was received. This then is your proof that the document was filed. However, a lot of pro se litigants are permitted by the federal court, and of course, all of the lower courts permit individuals to simply take 2 copies of your document, have one file, which is the original, and a court clerk will usually timestamp and date a copy for your records. Now, all of the information provided here today can be found in my book, Can I Represent Myself? A Self-Help Guide for the Self-Represented Litigant. And of course, when you open the book, the first thing that you'll see is my reminder that this guide is offered for educational purposes only, and it's not intended to substitute for legal advice. Additionally, I make it very clear in the book that while every person has a right to represent themselves in court, I do not recommend that a criminal defendant represent him or herself because the stakes are really too high. There is no margin of error when someone's liberty is at stake, and I would strongly urge against any criminal defendant representing themselves. And in most cases, even in civil proceedings, sometimes it may be ill-advised to represent yourself. But again, this channel is dedicated to making the law accessible to real people who may not have had the opportunity, the inclination, and most certainly don't have the time to do the research necessary to represent themselves in court and may have never been engaged in any type of court proceedings. So minimally, the book will help people understand how the process works, what is supposed to happen at each stage in the process, and most definitely how to be of assistance to your counsel so that hopefully you will be successful in your litigation. As I scroll down, you see the table of contents, and at section 2.3 of the book, putting it all together, I cover the rules and procedures for filing a case in court and the general rules for filing and answering a complaint. Under the rules and procedures for filing a case in court, I indicate that you really do need to know the rules affecting your particular jurisdiction, which requires you to do your own legal research. I also touch on the fact that federal courts are required to maintain public websites that contain docket information and all written opinions issued by the court. This can be crucial to your research in terms of finding out how the court has decided cases like yours in the past. And down in footnote 98, I provide a link to the PACER system, which is the public access to court electronic records, where you'll find PDF copies of every case and every pleading and every document filed in every federal court in the nation. But as I indicated earlier, each court has its own electronic filing procedures, which typically exempt pro se litigants from having to comply with it. So for the most part, pro se litigants are still allowed to file documents by hand, sometimes by mail. But it's important to know that this system is available to you as a means to obtaining information about your case and other cases. I also note that when you're filing documents with the court, you have to be careful to keep personal information out of the document. And that is to say, information that's not required as part of the lawsuit. For example, social security numbers and things of that nature should not be part of any document you file with the court, because any document you file with the court becomes a public record and anyone can go in and read that information. And now, because most courts have some degree of e-filing capacity, anyone with an internet connection could potentially view documents you file with the court. Down in section 2.3.3, what is a complaint? You'll see that I explain what a complaint is in a little bit more detail than has been provided in this video, but the key takeaway points are highlighted and definitions for legal terms are provided usually in text boxes that I embedded throughout the book so as to make those definitions easier to digest. Below that, I explain what an answer is, and the definitions of cross-claim, counterclaim are also provided. Below that, this is the exhibit that I provided earlier, illustrating both the rules being implicated in John's complaint and the rules upon which Sally relies in her answer. Next, there's a discussion of affirmative defenses, and I list the affirmative defenses that are recognized by the federal court, which is to say recognized by most jurisdictions in the Republic, together with a word of caution about making an affirmative defense that is not grounded in a good faith basis. And beneath that is a treatment of the timelines associated with filing and answering complaints, as well as all of the timelines associated with a civil proceeding in the federal court. And again, all state courts and city courts have rules, and all of the rules have attached time frames which must be honored and strictly followed. And usually the consequence of not complying with the time frame is to have a document thrown out, sometimes referred to as stricken. And the ultimate penalty for not adhering to a time frame could be that your case or your answer, which is to say your defense, could be thrown out or dismissed, leaving in place the other side's complaint, defenses, and requests for relief. So it's crucial to comply with all of the timeframes governing the proceeding in which you are involved. Well, that concludes this video. If you find the information in this video helpful, please be sure to share it with other individuals. Additionally, stay tuned for other videos that I will do concerning the law or legal processes aimed at helping real people understand the law. Finally, we profess the truth that we can do nothing without God. God bless.